Good morning. We're going on video record on October 30th, 2024 at 10:25 a.m. My name is Phil Love, and I'm the legal videographer, and the court reporter is Amy Garrett. We're both here representing Esquire Deposition Solutions. This is the beginning of Media Unit 1, the deposition of Bradley Johnson in the matter of Colin Ward versus Timothy E. Baxter and Associates, PC, and Bradley Johnson, debt collector. Filed in the U.S. District Court for the Eastern District of Michigan, case number 23-12519. Today's deposition is being held at 418 North Main Street, Royal Oak, Michigan, 48067. Counsel, will you please identify yourselves for the record?
Yes, thank you. Brian Parker for Colin Ward.
Good morning, Bradley Johnson, representing Timothy E. Baxter and Associates, PC, and myself, debt collector.
Thank you. The court reporter, please swear in the witness.
Thank you. My name is Amy Garrett, Notary Public and Digital Reporter for Esquire Deposition Solutions in the state of Michigan. I'll be capturing the verbatim record of today's proceeding using electronic audio equipment, a computer, and specialized recording software, which is not a form of stenography. The witness has confirmed his identity with a driver's license issued by the state of Michigan. Absent any objection at this time, counsel and the witness agree to my administration of the oath to this witness, and that the final transcript may be used for all purposes allowed by the Michigan court rules. Hearing no objection, this will constitute agreement and stipulation of such, and I will now swear in the witness. Sir, do you swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can lower your hands.
Thank you.
Good morning. May I call you Mrs. Johnson?
Please.
Have you ever given your deposition?
Not badly.
Okay. Have you ever given your deposition before?
Yes.
And what kind of case was it?
It was your buddy, Nicholas Reyna. He sued my client. Very similar to this. Had my deposition. Obviously, that case was dismissed with prejudice. Very similar situation.
Did you sign a release on it?
No, it was dismissed with prejudice after a motion for summary judgment under Rule 56. Judgment on the pleadings.
So you're saying it was a federal case?
It was, yes.
And what were the parties' names?
Velocity Investments, LLC, was the defendant, and the plaintiff, I believe his name was Michael Lovette, L-O-V-E-T-T-E.
And it's Western or Eastern District?
Western, District of Michigan.
Okay. So the reason I ask that is you've given a deposition before. The ground rules are quite simple. It's being given under the auspices of the Michigan court rules and the federal court rules. The deponent is, you are saying that you've given a deposition before. You know this is quite a small area. So if you can't hear me, stop me and ask me to repeat. And that goes for if I mumble, which I often do, so that we have sort of an agreement that if you answer, you've understood what I'm asking you. Is that correct?
That's correct.
That's correct. Before we start, have you had any alcohol before this deposition in the last 24 hours?
I had some mouthwash that might have contained some alcohol, but other than that, I'm sorry, I had a beer last night. One 12-ounce Miller High Life.
All right, and I don't want to mischaracterize, but you seem sort of agitated. Is that correct?
Yes, I've filed a Rule 11 motion against you and your client, and you have called me every name in the book, and you said I deserve death threats because of what I do.
That's why you're
agitated. I'm not done.
Okay.
I'm not done. You've said you want to punch me in the face. You have insulted my clothes, my appearance, everything about me. So I don't know what this is about.
Are you on any kind of medication this morning?
Yes.
Do you want to tell me what it is?
No, but I will anyway.
Okay.
Lisinopril. L-I-S-I-N-O-P-R-I-L.
Is that a blood pressure medicine?
10 milligrams, yes.
All right, I don't want you to tell me. I'm saying anything that, and the only reason it's relevant is anything that impacts your thinking or behavior today. Is there anything other than a blood pressure medicine?
I took vitamin D this morning. I don't know if that does affect my
Is that
mood.
it? That's it for the medication?
Let me think. Yes, that's it.
Okay.
So now you have that. That was the whole objective of your deposition, right? To find out what I was on?
I haven't started the deposition.
Okay, keep going.
So you represented a Security Credit Services LLC against Colin P. Ward, case number 23 from MH071299-GC. Am I correct with the case number and the parties involved?
You're correct on the parties. I don't know the case number offhand. You are reading something, so I'll take you at your word on
All
the
right,
case
so
number.
I'll give it to you for your refresher, but you've taken my word, that's all right. And that was filed in the 43rd District Court, is that correct?
That is correct.
So you have been working at, what's the actual name of your employer?
Timothy E. Baxter and Associates, PC. There might be a law offices in front of it. I don't know.
Okay, and that's your current employer. How long have you worked at the law office or Timothy Baxter, PC?
There's two questions there. So what are you asking?
How long have you worked there?
Where?
At Timothy Baxter.
9 years.
And how long have you been a member of the Michigan State Bar?
Since 2011.
Where did you work prior to Mr. Baxter's office?
Law offices of Christopher Traynor, Trainor.
And how long was your employment with the law offices of Traynor?
Year and a half to 2 years. Don't remember.
Was that your first job out of law school?
No.
What was your first legal job after passing the bar?
I was right after 2000, and it was still really bad here in Michigan, so I was actually still clerking when I passed the bar.
Oh, okay, can I just stop you for a second? You don't have to say it's really bad. You do what you got to do. I'm not judging you on where you work. Just tell me where you worked.
Thank you. Levine Benjamin, PC.
Okay. And Levine Benjamin is not one name, it's two names, Levine Benjamin?
Yes, Levine space Benjamin space PC.
All right. And you said you were a clerk there. Did you get a job offer from that place after the bar?
No.
And so you needed to work, obviously, and your first job as a lawyer then was the law offices of Christopher Traynor?
No.
No, what was your first job? 'Cause that's what I asked you.
You didn't. You asked where I worked before I worked at Timothy Baxter and Associates.
All right.
After I worked at Levine Benjamin as a clerk, I worked for Bradley Putney in Traverse City.
How long did you work there?
3 months.
As an attorney?
Yes.
Was that your first job after passing the bar?
No. I asked and answered. No.
No? What first legal job after passing the bar? What was it?
I was still a law clerk.
Excuse me, as a lawyer, sir.
Oh, thank you for the clarification. Yes. Bradley Putney.
First job, and then you left after only 3 months?
I was fired.
All right, why were you fired?
Personality conflict.
I can't imagine that's the case, but I'll take your word for it.
Yeah, who do you work with?
You're supposed to be here.
Yeah.
Anyway, so may I remind you, and it's important, you're going to depose my client, that you are the one being deposed. If you have to ask me questions because I am not clear, then please ask me to clarify. But as a deponent, you're not, as you know as an attorney, you're not asking questions, you're just answering them. Is that fair for me to remind you?
I'll ask you a question if I don't understand what you're asking, or
Which
if
is
you
what- yeah.
mischaracterize prior testimony. I will
Okay.
be asking about that,
All right. Okay.
which you just did.
Okay. So other than that, you don't need to make comments or judgments about how I run my law firm or ask you questions. Is that fair enough for me to ask you not to do?
No, because you do that to me. So no.
No, in
it's
this
not.
deposition, sir.
I'll answer the questions as I'm instructed. I am under oath, so I will answer the questions truthfully.
So you lasted only 3 months at this Fred Putney? And
Bradley Putney.
Bradley? And what
Yes.
was the job after that?
Not badly. Well, after that, after I was fired, I went back to Levine Benjamin for a couple months.
As an attorney or a clerk?
Clerk and attorney.
Oh, good. So you were just doing, were you hired as a clerk or attorney or both?
It was a clerk.
Okay.
I
And how
had an
long-
unemployment claim, and they said, if you're coming back, you might as well work for us until you can land on your feet.
That's nice. And
Yes.
where are they located?
Southfield.
And what type of work was that?
I worked under a Greg Lipschutz, Lipschutz, I believe. That could be wrong. He was this is a Social Security firm, so he was kind of their auto, general negligence guy. When people called in with Social Security claims, he kind of did everything else.
Okay, I like that. But I just asked you what type of work, and then you went into details about your supervisor and other things. Could we just restrict it to the basis of my question, if you don't mind?
I'm just going to answer the questions.
Okay,
If
sir.
you don't like the answer, I'm sorry.
No, I'll be very, very honest with you in that when I depose somebody, I think to myself, how would I counsel that person? And I'd say as little as possible. But you seem to be going on and on. It's just you can take it for what you want. I wouldn't keep volunteering information as you're doing. You do what you want.
Thank you. I'm an open book.
Okay.
Everything's in the Rule 11 motion.
All right. So you filed, as we said, a lawsuit, and I'm going to hand you. Did you bring me? Oh, how nice. You want to call it 1 or A? What's best for you?
Either one's fine. One's good for me.
1? Okay.
Why aren't you looking at me?
You?
Yeah, when you're asking your questions.
I have a lot of hard work, and I've got to focus. I have a problem with focus, so if I'm looking at you and looking over here, I just got to stick to my
Because
job.
when I talked to you last, you said it was weird that I wasn't looking at you in court, and now here we are, and you are doing
Well, you
everything
did-
in your power not to look at me.
Mr. Johnson, I did give you an explanation. It's a hard job to depose somebody. So would you allow me to just focus on my job? I mean, I can stare at you all you want afterwards if that's what you want, but I just want to focus.
For the record, you're still not looking at me, but thank you. Go ahead with your next question.
All right, I'm going to hand you what you mentioned earlier about I think you called them initial disclosures. This is part of the initial disclosure. I'm handing this, what's marked as Exhibit 1. Would you verify that there is a summons with the case number that I referred to?
Okay,
And
summons.
then- and there's a complaint, 2-page complaint,
Yes.
and that's, if you will, that's your signature, is that correct?
Yes.
I'd asked you previously when you handed me your ID if that was your signature, and you waved me off. And the reason I asked is because this signature is nothing like the signature on your ID. Is that purposeful on your part?
What do you mean purposeful?
Meaning, do you purposely do like I would call it a work or a business signature for your filings? Or am I just imagining that it's different than the signature on your ID?
It is different, yes.
Is that reasonable? Is it purposeful? That's all I'm asking.
I sign them as fast as I can. As an attorney, as I'm sure you're aware, I sign a lot of documents. So I try to just sign them as quick as possible. Sorry, it's sloppy.
I did not say that. All I said was different. And you say you have a lot of time. You don't have a lot of time. But the signature is much longer than your one on your ID. It seems it would take a lot more time to sign like that given the fact that you're saying now that...
Would you like
do
me
it
to give you a demonstration?
No, but I might, but not now. So is the next page, would it be helpful for you if we wrote numbers on the pages, or are you okay with just taking a look at what we have so far?
Well, for the record, it would be nice if you numbered every page so that if this transcript's ever looked at again, the people know what you're talking about.
So that's a no?
That'd be a yes. Please number
Okay.
them.
You want to number them? Okay, go ahead.
So we're on page 4.
Yeah, page
Okay.
4 is the beginning of the loan application.
Perfect. Ask your next question.
Page 5. If you don't mind, I'll conduct the deposition the way I want to. And I say that very politely. Thank you. And then we'll just confirm the numbers. Oh, by the way, at any time if you need to take a break, feel free. There's no hurry.
Obviously.
No, sometimes attorneys will depose others in a hurried fashion, and it's not good to do that. You should take your time. So I'm at 15, and number 15 for me, just to verify with you, is what's titled Genesis Credit Union Notice to Co-Signer. Is that correct?
Thank you. That is my 15 as well.
All right.
Could have numbered these before. Would have been
Okay.
a lot better.
As I said, it's a lot of work for me.
Oh, yeah. We spent 15 minutes reorganizing the
17,
deposition room.
18, and then 19. Let me see. Let me just do the final page. 20 is affidavit of debt and verified bill of particulars. Is that what your 20 is?
No. Can't even number right.
What is your 20?
Oh, I'm sorry. You're right. Affidavit of debt and verified.
That'll be the
bill
last
of
time you say
particular.
that today. 21 is assignment. Is that correct?
Correct.
And they've all got the markings of the 43rd District Court on them. Is that correct?
I have to look
That
at every.
stamp?
I have to look at every page. Yes. Thank you.
Did you write this complaint?
Yes.
Is it a form complaint, or did you add things to it other than the name of the defendant and the name of the plaintiff and bank?
It's a form complaint, but I did make modifications.
All right. So the summons, you typed, or you had someone type it for you, or you did it?
We have a program that just automatically does them.
All right. Do you ever read the summons, what it says?
Yes.
And at the bottom it says, it appears that this summons is pursuant to 1.109D. Do you know what 1.109D is?
It's a Michigan court rule.
Okay, and do you know what it means, what it represents?
Not offhand, no.
I think it's about private information, what can or cannot be displayed publicly.
No.
There's 2.102B, do you see that?
I do.
MCR 2.103, do you see that?
I do.
And do you see MCR 2.104?
I do.
And do you see MCR 101, is that 105?
MCR 2.105 is what I have.
Okay, and do you know what that represents?
Not offhand, no. I'd have to look it up. Assuming
Okay.
it has something to do with service, or
Why are you assuming that? Are you guessing?
because SCAO, they put like the relevant law or court rules at the bottom of every form.
Would you
Don't you
like
know
to
that?
look up on your phone what that is?
No.
Would you like me to hand you the rule?
I don't care. What? Just keep going.
So that's a no. Okay, so the reason I ask is because all lawsuits run through MCR 2.105, correct?
I don't know.
As far as personal service. You don't know about personal service or certified service? Is that your testimony?
I'll have to look up the court rule. Do you want me to do that?
Before you do that, let me ask you,
Is this Jeopardy?
I guess, no, because I would give you the answer and then you say the question. That's Jeopardy. Maybe it's something else.
Shazam.
So you would have to follow the court rules to serve a lawsuit. Is that correct?
Yes.
And you'd have to follow the court rules to write a lawsuit. Is that correct?
I think so, yes.
All right, so which court rule do you follow when writing a lawsuit? Maybe a summons.
I don't know. The ones that relate to writing a lawsuit?
How many lawsuits does your office file a day?
I don't know. We do about 50 a week, so 10 a day.
50 lawsuits? All right. And at this point, you've been working there 7 years, and you still don't know the court rule on how to write a lawsuit? or
I've been
serve it?
working there 9 years,
All
not
right.
7.
Yeah, I know. So 9 years, and you still don't know the court rules? Is that what you're saying?
Not from memory, no.
All right. Take a look at 2.105. Let's hold on a second. Would you like me to hand it to you, or do you want to use your own research?
It'd be easier if you just handed it to me.
Okay. So the answer would be yes, hand it to me.
Are you testifying for me now?
I just went online and encapsulated 105.
You didn't know it off the top of your head?
Which one do you want me to know? Ask me a section. 1 point.
I don't care.
Okay. Well, that was your question. So go ahead. Does that encapsulate what you believe the service of process rules, complaint writing rule? Well, just focusing on 2.105, which is the service of process rules. Does that
Mr. Parker,
does that remind you or refresh your memory that you said you weren't able to do because you don't memorize these things, there's nothing wrong with that.
what's your question?
Does that refresh your memory as to 2.105?
What you handed me is called Service of Process Table. It is not a copy of the Michigan Court
All right,
Rules.
let me hand you the rules. There's the rules. I just thought it'd be easier for you to encapsulate it, because now you got to read like 5 pages. Do you want the rule, or do you want to just look at
I would like the actual rule that you're quoting to, not this summation.
All right, you want to do it that way? You keep that, and go to 2.105 A1 and A2.
I don't have it.
Let me have that.
You said I could keep it.
Let me have it. Thank you, sir.
Here. For the record, I handed Mr. Parker his thing.
And here's the rules.
Thank you. For the record, I am looking at Mich Court Rule 2.105, what's purported to be.
Mr. Johnson, everything's to the record, so you don't need to say that.
For the record, thank you.
Okay. So, 105, if you will, are you familiar with that rule?
Yes.
Would you see A, there's 2 parts to it, is that correct?
2.105A, is that what you're referring to?
Yes, sir.
Yes, 2 parts.
And what are those 2 parts?
Subsection 1 and subsection 2.
Read 1 and then read 2.
Allowed?
Yeah, no, I don't want to encumber you with that, but would you agree that that is the rule saying you can serve by personal delivery, or handing it to the person, or you can send it certified mail? Is that correct?
No, that is not correct. You have to send it certified mail, return receipt requested, restricted.
Okay.
But other than that, your summation is good.
So, is it A1 and A2?
I don't understand the question.
Excuse me. See, A1 and A2? One
what
is you can serve by delivering a summons and a copy of the complaint to the defendant personally.
Okay.
And then 2 says sending a summons and copy of complaint, the way you were talking, by registered or certified mail, return receipt requested, and delivery restricted to the, as you said, restricted to the addressee. Do you know what that means?
Yes.
What does it mean? You said you know.
Restricted. You mark it on the green card,
Right.
and then the postal worker is supposed to only deliver this package to the addressee, not a household member.
Right. The rule then says service is made when the defendant, in this case would be Mr. Ward, acknowledges receipt of the mail. Is that correct?
I don't have it in front of me. You took it from me and are reading from it, even though you said you know these by heart.
A copy of the return receipt signed by the defendant must be attached to proof showing service under subrule A2, and correct me if I'm wrong.
That's what it says.
Okay. So it appears that the Supreme Court that promulgates these rules for us is saying you have 2 choices. You can either serve personally or certified mail return receipt requested. Is that correct?
I'm not going to speak for the Supreme Court.
Is that what the rule says?
That's what it says, and there are other rules in
just asking about that rule.
2.105A
Okay.
or
So,
B, whatever.
As far as you know, Mr. Ward's an individual.
As far as I know.
Right. So as far as serving individuals, the rule does not say you can serve personally, or it's any better than serving if you serve by certified mail. Let's just say A2 will refer to it as certified mail. If that isn't how you want to refer to it, fine. You tell me how you want it referred to. But there is no, the question is, there is no requirement that you must serve someone personally. Is that correct? But under the rules. I know you operate differently, but under the rules.
No, it's either or, but courts, judges, I think the defendants, everybody prefers personal service.
Yeah, but that's why there are rules. So under 2.105,
You know all the rules.
A1 and A2, neither one is mandatory. You have a choice to either serve someone personally or by certified mail. Is that fair to say under the rules?
That's fair to say, but the Supreme Court did put personal service as one, so I guess under my thinking, they want that done.
I'm not
I
sure.
think that's the
I'm not
best.
sure what you mean.
If they thought restricted delivery was the best, they would have put that as subsection 1.
Well, if you would look at the rule again, I apologize for not making this. It says or.
Oh,
It doesn't
okay.
have a preference. So
All right.
you have a choice of either 1 or 2. Is that fair?
Or FedEx, like you do, but go ahead.
All right, 1 or 2. Is that correct?
Correct.
All right. And I bring this up because we're referring to the summons page that you created, and you follow the rules. Is that correct?
I try to.
What does that mean? You do or you don't?
I try to follow the court rules
Okay.
every day.
So
I
here's
live by them.
You do?
Yes.
What does that mean? You live by them,
They're the court rules. You gotta follow them. Like,
even if judges think differently of the court rules.
you know, like when you
No, just
filed a motion and then didn't even seek my concurrence under local rule 7.1A. You didn't follow that court
Mr.
rule.
Johnson, that doesn't impact your following the rules, does it?
Oh, what's good for you isn't good for me?
Is it? So you do break the rules because you believe I break the rules? Is that what you're testimony?
No, I strive
For
to
the
follow
record?
the court rules at all times.
Okay, excellent.
Unlike you.
Okay, I'm glad to hear that. So your complaint, if you would go to page number 2, and your summons state that Mr. Ward resides at 1400 West 9 Mile Road, Apartment 8, Ferndale, 48220. Is that correct?
That is correct.
And where did you get the information? Let's see, this was filed February 3rd. Where did you get the information that that was the case, that Mr. Ward lived at that location?
I don't recall.
Well, you've had this case for quite a while, a year, since we filed the motion to set aside the judgment you had against Mr. Ward for filing at the wrong address, that the court agreed was the case. You're saying in all that time, you have no recollection of why you served Mr. Ward at that address I just mentioned. Is that correct? That's your testimony?
No, that's not my testimony.
Okay, what's your testimony? Why did you use that address?
I don't know if the client gave us that address, if we scrubbed Mr. Ward's information and found this new address. I have no idea.
What new address are you talking about?
This Ferndale address that you're referencing.
Okay, the new address as opposed to what?
His parents' house.
Okay. And he at some point lived at his parents' house?
I'm assuming.
Well, you brought it up, I didn't. How do you know?
I lived in my parents' house for a long time.
Yeah, but I'm not asking about him, about you. I'm asking about Mr. Ward. Did you receive information that he lived at his parents' house for you to say that?
I'm assuming he has lived at his parents' house at some point in his life.
So your
And my understanding is
Yes.
that he moved back in with his parents after this Ferndale address. That's my understanding. I don't know for sure.
Where do you draw that understanding from?
From conversations with you.
Okay, and that's it. There's no paper or a database of information where you drew an address of his parents' house as his residence before and after this Ferndale address.
I don't understand that question.
You have not looked at anything to show his parents' address and his living there. Your whole basis of belief that he lived with his parents is that you got the information from me. Is that correct?
Yes, and what he put in his affidavit. I don't know.
Well, you
I don't know
and
your
you don't.
client.
Okay, so you're saying he put something in an affidavit,
Right.
and that's where you first learned about his parents' address. His parents' address is 6954 Arrow View, West Bloomfield, 48324. Is that correct? If you know?
I don't know. I'm assuming it is, but I don't know.
It's address of his, at least. Is that fair?
What's fair is this was an address he listed in December of 2011. That's
Okay.
fair.
Let me ask you again. Well, no, actually, not again. When did you first learn about the West Bloomfield, let's call it the West Bloomfield address, his parents' address? When did you first learn about that?
I don't know. It's always, I guess when I looked at this document, number 4, plaintiff's 1, page 4.
Okay.
This had this address.
And what are you referring to? The permanent address?
Yes, from 2011.
So did you look at that before you filed the lawsuit?
Yes,
And what,
obviously.
I don't know if it's obvious. And
It
what?
was redacted. Obviously, somebody looked at it.
Well, I didn't redact it. I got it from you. So
Okay,
what?
you can add 2 and 2. There
So
you go.
did you get this address? Are you saying the first time you learned about this address was from the loan application that you're referring to as Exhibit A, page 4?
I don't know. I really don't know.
Because before you said, I first learned about it from an affidavit of my client. Which one is it?
That was when I guess, understood that he moved back with his parents.
The affidavit is in July of 2023. Are you saying that's when you first learned that he was at the address? That's the very first time that he had moved back to that address. Is that your testimony?
No.
All right. So let's go back to my original question. When did you, Mr. Johnson, working for Timothy Baxter, first learn that he had moved back to his parents' address?
When he faxed and emailed and mailed and mailed certified mail, and I don't know if he FedExed it or not, his objection to garnishment, which I believe you prepared.
Okay, so that's the very first time you learned. Is that your testimony?
No, actually, it's not.
Because you keep changing. Which one is it?
It's hard to remember. I forgot. Let me correct it. We first learned that possibly he did not live at the Ferndale address anymore when we had already gotten a judgment, and under the Michigan court rules, we had to serve him with the judgment. So we mailed it to the Ferndale address, and it came back bad. That was the first time.
Let me see if I have that envelope so I can refresh you. Do you know the date that happened?
No.
I'm just, and the reason I ask is I'm just going off the documents you gave me.
Right. I don't know offhand. I didn't know he moved back in with his parents. So sue me. Oh wait, you already are.
So let me hand you, let's make this exhibit 2. Yeah, I'll just let you do it. I'm going to hand you what's exhibit 2. Is that the envelope or notice where you learned that Mr. Ward lived, or may, as you say, have lived or moved back with his parents to Arrowview Street?
No.
No? What did you receive? Those are 2 envelopes that you sent to Arrowview Street. Are you saying that wasn't what showed you that he had moved with his parents?
Yes.
Something else?
That is what I'm saying.
What is that something else?
It would be the return envelope that we received from the mailing to the Ferndale address.
Which you did not give me as part of your initial disclosure. Is that correct?
I don't remember. I gave you over 400 pages. I think it's included. Do you want to go look through them again?
Well, it isn't.
Oh.
That's why I use these. You sent me these, and they do have the 41st District Court marker on them.
For the record, no, they do not.
It's right there. The bottom, that's strange. You're right. Oh, sorry. I gave you the, well, no, you're right. Wait a minute. These are 2 others.
Great
Nope,
job.
These aren't what you sent. You're saying those envelopes aren't what you sent.
I only have 1 page. You have 2.
It's
So
the
can we
same
get
copy.
on the same page here?
Are you saying those aren't the envelopes that you sent out, though you did not send out from Baxter's law office? For the record, Exhibit A, Exhibit 2.
No, we sent them to the Ferndale address. Then they were returned to us.
Okay. And I believe you sent the copy of the default, is that correct, and judgment to the Ferndale address?
Yes.
All right. And that was approximately May 22nd?
I don't know.
All right. Is there something that would refresh your memory?
Yes, a proof of service or something. I don't know exact dates. Sorry. I guess neither do you.
We're going to mark this as Exhibit 3. I'm not going to make that much reference to it right now. Thank you. Mr. Johnson, I'm handing you what's marked Exhibit 3 in reference to my need. Hopefully it helps refresh you of the May 22nd letter that you sent advising Mr. Ward of the judgment against him from the 43rd District Court. Is that what you're using as reference, or what you used to send Mr. Ward identification that he has a default judgment against him?
I didn't sign this.
Okay. You're saying it didn't leave your office?
No, he sent it out. I didn't send it.
All right. And then you sent it again, if I might, around July, but this time to his Arrow Drive Road. Is that correct address?
That is correct.
So you've now changed the story. Previously you'd said you only learned about the Arrow Drive address and his living there again when you received his objection to garnishment, which was, I think, July 20th. But this is a letter you're sending out in early July to that address. Why is that different than the story you previously told?
I forgot that, yeah, we had sent the judgment letter to Mr. Ward in Ferndale, and it was returned to us. I'm sorry, but that's what happened.
All right, we're just seeking clarification here. So
Thank you for the
when you
clarification.
you're on the phone, if you don't mind.
Sorry, I got other stuff going on.
So why did you send it out to the Arrow, let's call it the West Bloomfield address, around, it looks like July 11th?
Because that was the only other address we had for this guy.
But the letter that you sent him was a copy of Exhibit A, the letter on Exhibit A.
Yeah, that was sloppy.
Okay.
What exhibit
Where-
again? It's one or
Excuse me,
two.
Exhibit 3, I apologize.
Thank you.
Where did you get that address from?
I don't know.
When I say the address, the Exhibit 2 envelope, where you're sending it to his West Bloomfield address, where did you get that address from?
I don't know. I'm assuming it was the only other address listed for Mr. Ward at the time.
You mean that was the first time that you found that address that generated that letter to him?
No.
No?
That's
Okay.
not what I said.
Did you look at something that showed an address of Mr. Ward at Arrow Drive prior to that?
Yes, it's on his application from 2011, as we discussed.
And it's called what, a permanent address?
In 2011, yes.
Okay,
We're in 2024 now.
okay. So, did you, I heard you say the word scrub. What is a scrub?
Well, we have to comply with all sorts of rules and regulations. We're the only subset of attorneys that can be sued like this for, I would say, trivial violations. So we scrub for deceased, new addresses, bankruptcy, active military, all that fun stuff.
Did you do a scrub on this case?
Yes,
How do you know?
because we do them at certain times in the
You do,
litigation
or someone
process.
does it? Sorry, I stepped on you. Please
Yeah.
answer, I apologize.
I scrub them when I'm filing the lawsuits. Other people scrub them when they're doing other things.
Did you supply us anything that showed you, if you will, scrubbing?
I think so, yeah. I think there's an
Well-
attorney suit review checklist.
So
I think
what-
I provided that to you.
Okay, what would I seek among the paperwork that you sent me to show, and again, these are my words, to show the scrubbing?
It would be an attorney suit review checklist.
That, that does not seem familiar to me, but I will look in your papers, and it won't take long.
If it's not in there, I apologize. I will supplement, as I just did this morning.
And what is it, the title of it again? Because it's new to me.
Attorney suit review checklist.
Okay.
Do that for the, I forget what it's called, but meaningful involvement. There you go.
What does meaningful involvement mean?
I'm sure you know, but
Thank
it's an attorney can't just be in an office all day just signing 800 lawsuits a day.
how about 10 a day?
I don't know if they're scrubbed properly.
All right. And you're 100% sure that this was scrubbed properly, as you say? This case,
Absolutely.
based upon? Based upon what?
Your client's clearly alive. He's not active military because he's here. He didn't file bankruptcy. And that was the good address. We had a good postal verification for the Ferndale address. And, I'm not done, when we sent the certified mailing to the Ferndale address, somebody signed for it as an agent of Mr. Ward, which is interesting.
Is this the address? Is this the envelope? I received this from you.
Oh, you do have it.
Well, no, I looked for it.
You said I didn't give that to you before, but now you have it.
Oh, okay, you're right.
Yeah,
Sorry
thank
about that.
you.
Make this 4. I'm handing you.
When you do stuff double-sided, you can lose track. That's why I don't do that.
Well, I don't know if this is the letter that you're referring to, so it wouldn't be fair of me to say I now have it. I'm going to have you tell me if it's the letter you're referring to. I don't have what you are referring to, but maybe and hopefully I do. Is that the letter that told you that you had the wrong address?
Yes.
All right. What date is that being sent to Mr. Ward?
For my review, May 24th, 2023.
2023. Okay. And that came back to you, clearly wrong address. He lives somewhere else. What does it say on the envelope, actually?
Where?
As to the reason it's been returned.
Oh, it says return to sender, not deliverable as addressed, unable to forward.
Okay. Do you know what that means in your vast experience of probably seeing that more than once? What that means?
I don't know.
Would it mean that if there was a forwarding address, it had expired?
I don't know. I'm not a postal worker. I don't know what unable to forward means.
The scrubbing that you did you find any information about Mr. Ward's driver's license?
No.
Nothing about his listing as a state ID or anything like that?
No.
You seem surprised by that question. Why?
I didn't know that driver's licenses were just readily available. I know they're readily available for your client because you posted it on a federal
All right.
lawsuit, unredacted.
Okay. So did you not search any state database? Meaning, remember I asked you what scrubbing meant? So I'm continuing that inquiry. So that's not part of scrubbing, is that correct?
If you can tell me what this state database you're referring to, I'd love
All right.
to use it in my scrubbing.
Well, that's why I'm asking questions rather than making arguments. I'm saying, if you have a database that you use to scrub, does that include searching the guy's state ID, address, information, anything like that?
I don't know. We use LexusNexus. I don't know what they do.
All right. Does the person's state ID or address information of any kind come up when you use LexusNexus?
No.
Okay. So you did not receive any information, or did you receive information prior to Exhibit 1 being filed that said he was at the West Bloomfield address?
No.
You didn't?
No. To the best of my recollection. And usually, when we're looking for addresses, we don't think that the person moved back in with their parents. That's kind of odd.
That a person lives with their parents?
That
But
would
you
move.
have a history of, when losing a job, going back to another employer. Why is that any different?
I didn't move back in with my mom and dad.
Well,
I
how do
moved
you
to my
know-
apartment.
How do you know Mr. Ward did?
I don't know. These are the only two addresses listed.
Then why are you saying something you don't know?
Because your
And
client...
judging Mr. Ward when
not-
you don't know.
I'm not judging him.
Then why
I
are
don't
you
know
saying
anything
he
about
moved
him.
with his parents and it's unusual? Why are
Because
you
usually
saying
when
that?
you go out on your own, if you move somewhere else, you're moving to another place. Buy a house. I don't know. If you move back in with your parents,
If you
it does
don't
happen.
know, why are you saying that's what he did?
Because that's what he said he did.
He never said he moved with his parents. You did.
I don't know. You said it was his parents'
You
house.
are saying again that you don't know, but then you will say it even though you don't know it. That's why I ask, what's the basis of your knowledge that he lives with his parents at any time? What is the basis of that information?
Because I'm assuming his parents gave birth to him and raised him.
All right, so may we...
That's an assumption. I don't know.
He could be adopted, or that's not in your lexicon?
He could be.
All right.
Is he?
Do we have addresses on our state ID, and that means we live at that location? Is that what you're saying? Because I'm trying to figure it out.
I don't know. You're supposed to update your state ID
You're
when you move
saying
addresses.
You don't know. Yet you're continuing to say something as though you do know. Which is it?
I don't know. I
don't
will
know.
just speak for me. When I move, I change my address, and it's
Right.
updated with the state.
I haven't asked that question, though, so why are you telling me that?
That's what happens with me. I don't know what Mr. Ward did. I haven't taken his deposition. I have no knowledge.
All right.
Just going from
That's
what...
a fair thing you said.
I'm
Thank you.
just going from what you've told me in the past.
Well, you're not here. If I ask you what did I tell you, then
And when
please
you
tell us.
breached the attorney-client privilege.
Okay. So,
And you put his state ID on a federal lawsuit and didn't redact it.
so you are saying that, and you are continuing to say that. Why don't we just assume that you've said that and we don't need to keep repeating it? Is that all right?
You repeat yourself all the time.
No, so you're saying no, it isn't all right.
No, it's not.
Okay,
Let's just get this over with.
we're moving there.
Yeah.
So this information came back, so then you sent Exhibit 3 to Mr. Ward's Aero Drive, West Bloomfield address. Is that correct?
That is correct.
You did, or somebody from your office did?
Somebody from my office.
Do you know why it looks like a Joe Harris? Is that person in your office?
Not anymore.
Or why are they not working there anymore? If you know.
I do know. This is ridiculous. His son died.
His son died,
Yes.
so he had to leave?
Yes.
All right. Why is that ridiculous?
What does Joe Harris have to do with this lawsuit?
Oh, you said it's unsigned, and Joe Harris is the person that sent it. Does your office require that they sign?
Oh, you got me.
No. Does your office require?
No, they don't.
All right. So
And I don't know if he signed this or not. I don't know what copy your client got. He might have signed the copy that he got. I don't know for sure, but I'm sure your client would know.
In your office, you keep referring to people there. Mr. Baxter works with you at your office?
Not anymore.
What does not anymore mean?
He's in Florida now, just like you.
Is he retired?
Yes.
Does he come in and supervise the office at all?
No.
Why not?
I don't know.
How long since he last worked there?
Since 2020.
Really? Wow. Okay. I knew him for a long time. I did not know. Is he retired?
Yes, I've said that.
But he's keeping the business going?
We're trying to. I'm not doing much with the business today. but-
So who's there at the office when you're not there?
My coworkers?
And are they other attorneys?
No.
Paralegals?
Legal assistants.
Legal assistants?
We don't call them paralegals.
Who's we and why don't you?
We've hired paralegals in the past, and they don't really like this industry because it's obviously pretty bare bones, except for this case. But usually we're just doing pretty bare bones stuff.
What does bare bones stuff mean?
And we're not doing federal lawsuits. We're not doing med mal or.
You just said that you were in a federal lawsuit from, I think you called him my buddy, Nick Rayner.
That's outside the norm. Usually we're just doing
Okay.
collection work,
All right.
which is, except with you, they usually go pretty quick.
So you have Exhibit 1 in front of you,
I do.
and you have the lawsuit. So let's take a look at the lawsuit that you say goes pretty quick and it's bare bones.
The lawsuit your client settled, yes.
All right. You're asking for $12,585.81, and you keep putting in court documents, and now you're referring to it here that my client signed. Is that correct?
I don't understand
Did
that.
you receive $12,585.81 from my client? All right. Wow, it worked when you started typing. For the record, the lights went out, and we don't know why, but now they came back on again. So you settled this case. You were asking for $12,585.81. I don't think it's any mystery. You've been placing it in pleadings. You were asking for $12,585, and you settled it for how much?
Your client paid my client's security credit services the sum of $2,500 as a settlement of this debt.
So,
And the dismissal of his counterclaim against my client with prejudice. And hold on, I will further clarify. This case evaluated, my client's claim evaluated
don't
for...
say that.
I'm
You're
not
allowed to
done
proceed.
yet.
Okay.
I get to talk. It evaluated for $5,000. You got your little $1,500 off because of your counterclaim, which wasn't even anything special. So it evaluated for $3,500. Your client accepted that, and as you breached the attorney-client privilege, you told me that you told Mr. Ward not to accept that award, and he disregarded your advice and accepted it anyway, and then we took another $1,000 off, so he had to pay $2,500.
All right, so it mediated for $3,500, is that correct?
Yes,
And you settled for $2,500
my client did, yes.
on a case that you were suing my client for $12,500.
Yes.
And after the mediation, there was some question about the information that you used in your lawsuit. And is it fair, and correct me if I'm wrong, but you told me my client gave me a lot of junk. They really didn't give me much to work with. That's a paraphrasing of what you said.
Yeah, these were old student loan cases, literally right up to the statute of limitations. So, I mean, they're not the best, but
So
we
they
still sued it.
They had failed to give you enough information?
No, they gave us all the information. They just didn't give us a lot of time. And these are obviously old student loans.
Yeah, but you had said at the time they didn't give you enough paperwork, and what they gave you was junk. That's a quote
Quote from what?
from you.
Oh, well, if you say I said it.
Am I wrong? You did not say that?
I don't remember what I said over a year ago in a case evaluation panel, but I do remember one of the panelists, when you weren't there, was like,
Don't
what's...
talk about the pounds. You can't. 2.403.
It's over.
Oh.
The
No, you
case
still
is
can't.
over.
You still can't do it.
I'm going to talk about it anyway, and then you
All
can
right.
say whatever. But the
I'm not done.
panelists asked me, what's up with this Mr. Parker? Why does he hate you? Is Mr. Ward like his best friend or something? I don't get why he's going so
All right.
hard on this case.
Fair
That's
enough.
what a panelist said.
But you had made reference to the junk that your client gave you for
This
evidence and
isn't.
information.
You've
Is that
seen
correct?
my other lawsuits. There's better paper out there. That's what I meant.
I thank you. Thank you very much. In this case, you have a client and so security credit services. When you write a complaint like this, are you filing it after they reviewed it, or do they not review it before you file it?
I'm not getting into that. That's attorney-client. Not getting into it.
All right, so that's fair. Generally, do you talk to clients no?
I'm not getting into this line of questioning.
Okay.
You're trying to get around the attorney-client privilege. I actually respect the attorney-client privilege.
Okay, thank you. So you don't want to talk about...
I don't want...
Do you seek, without telling me, your client's approval on a lawsuit you're filing?
I'm not answering any questions that go to attorney-client.
Okay, I respect that. So you signed this lawsuit on January 20th, is that correct?
January 20th, 2023. Yes.
Did you have any information at that time that Mr. Ward's address at that time could be the Arrow Street or West Bloomfield address?
He could live anywhere, I don't know, but this
That
was the
wasn't my
address
question.
we wanted to use.
Did you have information that he lived somewhere other than the 1400 West 9 Mile Road, Apartment 8 address?
Not that I recall, no.
Okay, so that's a no. Let me hand you what is Exhibit 5. Fair enough, thank you.
I also had a postal service
very
verification that your client worked
wait until you ask the
there.
question, please.
I'll do what I
I'm handing
want.
you Exhibit 5. Let's do what I'm going to write it for you. Number 1. Number 2.
Yeah. You having fun yet?
So I believe this is 9 pages I'm handing you. You can check it out. And I'm going to verify with you some of the pages just so that we're on the same sheet of music. This is paperwork that you gave me. You're on your phone again. I would ask that you not go on your phone if that's okay.
I have kids, and I have stuff I have to look at.
You
I'm
told
sorry.
me that you wanted me to do a later deposition so you could take your kids to school, and I was open to that. So
Oh, well, thanks.
I was a single father myself, I understand,
Oh.
but I think you shouldn't really be on the phone during a deposition. It's just my opinion.
Well, thanks
Unless
for
there's an
your,
emergency. Is there an emergency?
thanks for your opinion.
All right. Do you have number 9? I don't know what it's called. Maybe
Number
you can tell me.
9, number 9.
Can you tell me what number? Yeah, it's a Beatles song. So can you tell me what number 9 is?
Number 9 is your client's motor vehicle locator results.
That's a automobile.
Yeah.
All right.
Registered to the Ferndale address, a 2018 Subaru Impreza station wagon.
And then number 8.
Number 8 is a TLO scrub showing the Ferndale address current from March 19th, 2018 to March 22nd, 2023. Excuse me.
Oh boy. And you provided this to me in your initial disclosures, I believe. Is that correct?
It's the only way you would have gotten them.
But when I just asked you if you had information that showed his address, you said, no, I don't.
Yeah, look at this. Are you on page 8?
Yes, sir.
Go to his ArrowView address. It says
All right.
current.
Can you ask my question first? I asked you, is there information showing what you used to come up with the Ferndale address? You said, I don't have any. But this appears to be, with the Ferndale address, information showing you he is at the Ferndale address according to this. So are you now being refreshed? Had you forgotten about this documentation? Yes or no?
You're asking like 6 questions.
All right, does this refresh your memory about the question I asked you? I'm being fair.
That's a really bad question.
Okay, I will retract that question. And why didn't you tell me about this paperwork when I asked you what you used to find his Ferndale and Arrow Drive address?
I believe what I told you before is that I didn't recall.
Okay.
I didn't know if the client gave us the Ferndale address. I don't know if we found it, but it looks like if I'm looking at Exhibit 5, page 8,
Correct.
it looks like, from just looking at this, like you just said, it looked like you live at Ferndale.
And is this part of your scrubbing? Is this the database I was asking you about, what you look at? as far as scrubbing?
Yes, this is one of our vendors.
Could you tell me, yes, what is this that you use to search for information if it's a location? What's it called? Is it a word for this sheet of paper? There's a couple actually you gave me. I've got 3. If you look at page, no, that's not. So page 8 and page 9, are those things that are printed or come out as a result of part of your scrubbing process?
Yes.
And what's the name of the company you use to produce this?
Page 8 would
Yes,
be
sir.
TLO.
TLO? What does that stand for?
I have no idea.
And when did you obtain this?
I have no idea.
Is there a way to know?
I'd have to look in my file and see when this was scanned into our system.
Okay. And that indeed, despite what you said you'd never heard the address, does say 6954 Arrowview Street. Is that correct?
It does list that, but just to clarify, it says that was current from January 2008
Okay.
to February 2023. And if you look above, we have a more current address that was from 2018 to 2023. So that's the address we're going to use.
What are you trying to tell me in regards to the Arrowview Street address? Are you saying it's not something you would search out because it is expired as of 2022? Is that what you're saying?
It looks like there's a phone number associated with this of a Patrick Ward. I'm assuming this was his family address.
All right, so we follow the rules, we follow the facts. I would ask that you not assume anything because it could be wrong, and so we want to put everything that's correct on the record if you don't mind.
No, you're
So-
the expert at that.
All right, fair enough. But this didn't warrant your further search as to his address when you're being notified of this address, which also is the address on page 4 of Exhibit 1?
I don't get it. You're gonna have to rephrase. 'Cause you asked like 6 different questions
You were
again.
saying you first learned about the address in July. But this clearly came before July because you said you used it to file July 2024. You filed a lawsuit in 2023 that you said you relied upon to find his Ferndale address.
Right.
So why are you again changing your story about having received notice of the Arrow Street, let's for the record, 6954 Arrowview Street, West Bloomfield? This notified you of that address, correct? Page 8, Exhibit 5, notified you of 3 addresses, is that correct?
3, well, actually 2 addresses, but one
Okay.
just has the apartment number. So,
All right, and so one of them is the Arrow Street address. So you did receive
Arrowview.
You did receive word of Arrowview's address associated with Mr. Ward well before July of 2024. Is that correct?
2023, not 2024.
No, you said the first time you learned about it was 2024. First you said when my client filed his objection.
Ooh, you got me.
Then you backtracked to the envelope that was returned in
Uh-oh.
July of 2024.
We better settle right now. You got me.
Excuse me. You're right, it's July, you knew July 2023. So before
Oh, thank you for that clarification.
before the lawsuit was filed, you were aware of the Arrowview Street address. The Exhibit 5 at page 8 notified you of that before January of 2023. Is that correct?
That was one of the addresses associated with Mr. Ward. Yes.
So, all right.
You got me.
I'm not trying to get anything. I really am not.
Well, that's not what you said on the phone.
Well,
Remember that convo?
I wasn't deposing you then.
Yeah.
So for the purposes of this deposition, I'm not trying to get you. I'm just getting to the truth.
Oh, yeah.
So
You're
we
great at
will
that.
go back to Exhibit 1.
Can we talk about page 9? Your client
Wait, I'll
registered his car at the Ferndale address.
What date?
In 2019.
All right. So why would that be relevant to what you're
Because there's no other address listed for his car.
219?
Page 9, I don't see any address for AeroView.
Okay, for a 219 listing, you're saying.
And if you go
4
to
years
page
before.
7 of your exhibits,
How about we restrict to my questions, if you don't mind?
I'm just trying
So,
to cut to the chase.
Page 2,
Page 2 of what?
I just said Exhibit 1.
Oh,
Thank
back
you.
to Exhibit 1. Okay.
You there?
I'm here.
Okay, so that on January 5th, 2012, paragraph 2, you allege that defendant and Genesis Credit Union entered an agreement or promissory note. Is that correct?
Yes.
And that's attached at page 4, and there's a number of pages.
Well, page 4 and 5 are the application.
So where's the actual agreement? I think that is the agreement. Private,
Pages-
educating line of credit agreement. You're right.
Pages 6 through 14, excuse me, pages 6 through 19.
This is everything you gave me. So this appears to
Yeah.
be signed the 5th of January 12. Is that
Okay.
correct?
I don't know, I have to get to that page.
By Mr. Ward. Go to page 14, page 14.
Page 14, okay. Gotcha.
And then it's signed by an Earl Robinson. Do you see that?
I see that, yes.
What work or search did you do into Mr. Robinson as far as his viability or culpability in this case?
The same scrubs we did for Mr. Ward.
You didn't sue him, though. Why is that?
Because we learned he was deceased.
Okay. And you see Mr. Ward is signed as borrower.
What page are you referring to?
Same page,
Mr.
14.
Parker? Oh, 14 again. Sure.
Okay. And then 3, you allege that Genesis Credit Union fully performed its obligations as defendant pursuant to the terms and conditions of said promissory note. Correct?
That's what it says.
And where are those terms and conditions?
Pages 6 through 19 of Plaintiff's Exhibit 1.
6 through 19?
Yeah, I guess.
Okay. And then you said that defendant defaulted in making payments on said promissory note, correct?
That's what I said.
And what proof do you have of that?
The payment log.
Payment log?
Obviously, our client forwarded us this claim, so we're assuming the debt was not paid, and it clearly wasn't because your client paid my client $2,500 after this lawsuit.
And so when someone files a settlement, the amount or the fact that they paid something to you means they believe they're liable on the debt. Is that correct? That's the only reason they make a settlement. Is that correct?
Well, if they have banger affirmative defenses like statute of limitations, I don't know why they would ever settle for anything. That doesn't make any sense.
Why did you then ask me to settle it? Excuse me, why did you ask Mr. Ward to settle it then?
Because my client wants to get paid?
Okay.
Why didn't you file a motion for summary disposition on this great statute of limitations defense?
What is an affirmative defense that you just said?
An affirmative defense is something that even if every allegation in my lawsuit is true,
Yeah.
your client can still get out of it.
Is that what the rule is?
That's my paraphrase of it.
All right, if you would, you referenced, you called it affirmative defense. I'm just making a record. What truly is an affirmative defense? Is it a pleading? Is it a rule-based requirement? Do you sign for it? Tell on the record what an affirmative defense is.
As I said, an affirmative defense is something that, even if all the allegations in this lawsuit were true, pages 2 through 3, even if everything in that lawsuit is true, this defense overrides that and says no claim, dismissed.
All right.
And statute of limitations is one of those affirmative defenses.
Okay, and so is an affirmative defense, Mr. Ward had affirmative defenses.
Yeah.
Must they be true when you allege them?
Must your affirmative, you file like 30 affirmative defenses for everything, so I'm assuming no. Most lawyers put every affirmative defense in their pleadings.
Okay, so that's not what I asked you. If you would refer to my question. Let's say you. All right, you want to do it that way? When you file an affirmative defense
I don't usually do that, but I did in this case.
and they were all true.
What? You
Meaning-
plead them.
You plead them. What does that mean to you? Again, for the record, I don't understand what you mean. You plead them.
Well, like you
Meaning,
do.
do you plead them all even though they're not true, or only the ones that are true?
I plead the ones that I think are true.
Okay.
I don't know what you do.
I'm moving on. So,
But like-
again,
like-
don't take shots at me, please.
Oh,
Can you just
you
answer the
take
question?
shots at me all the time.
Well, then you can fire back if you want.
That's
but
right.
In a deposition, I'm not taking one shot at you, so please don't take a shot at me if that's the basis of your reason to want to take a shot, because I take shots at you. Let's stick to this. You want to get out of here. I want to get out of here. Let's go and just answer questions. So as I wrap up, affirmative defenses, when you file them, you rarely do, but they're true. And do you sign for them?
I think they're part of your answer. Yes, you sign for them.
Why do you sign for them?
Because you're an attorney and you're filing something with the court, and you're not supposed to file stuff that's untrue. They have court rules for that, like Rule 11, which you're very familiar with.
That's a hill that you will regret.
Is that a threat?
No, meaning as we get more into this deposition, you just tied something up for me, and I very much appreciate. Remember, I said that.
Well, I'm an open book, so
I
just
know you are.
take your time. Where's your special guest?
Remember, we just said we were going to talk about questions and answers only.
I don't care.
Okay.
don't
So
care
you
what
have
you
a
do.
loan application at 4, and you advise that that's not an agreement.
was
The
an-
page 6 through 19 is the agreement. Is that correct?
That's what I said, yes.
Okay,
Thank you
thank you.
for actually citing my testimony accurately.
This number 5 of the page 2, exhibit 1 says the note was subsequently assigned to plaintiff. Forgive me for being a stickler, but when was it subsequently assigned and from whom?
My understanding is after your client defaulted on this student loan, it was sold and assigned to some Realax.
All right.
Realax.
Sounds like a real estate office or something.
I have no idea.
There is an assignment of sorts from
You said this was a good assignment.
page 21. Please go to page 21 of 1.
Okay,
And-
I'm there.
Is that fair to say that is Genesis Credit Union saying it does hereby assign, transfer, and set over to Realax Surety Company of someplace in South Dakota as assignee, that a certain promissory note executed by Mr. Ward and payable to the order of Genesis. So it appears to me that Genesis is assigning, transferring, or setting over to Realax Mr. Ward's loan. Is that a correct reading?
That's what my reading.
It says Exhibit A promissory note is attached, but in your complaint, there was no an attachment. Is the attachment what the promissory note between 6 and 19? Do you believe that's the case?
I have no idea. I didn't write this assignment, so I don't know what they were referring to.
Well, you wouldn't have added it to your lawsuit unless you'd done some research behind it, correct? I mean, you say you have no idea. You just attached it without any idea?
It looks like an assignment. But I
Alright.
don't know what Genesis Credit Union is referring to because I'm not Genesis Credit Union. And I didn't write this thing.
That's fair enough, but you use it as evidence to prove of an assignment. Is that fair to say?
I attached it to my lawsuit.
And there is no Exhibit A attached to this assignment.
I don't know that. I don't know what Exhibit A refers to because, as I've stated now many times, I did not draft this.
Yes, but getting back to your signature about the truth, when you sign something, you're signing for the documents as well as the lawsuit that you're proffering as proof. Is that correct?
I don't know.
You don't know whether that's correct? That you have to be signing something that's a good faith assessment and truthful of the case against Mr. Ward? You don't know that?
No, because you filed a lawsuit against me.
Let's stick to Mr. Ward.
We're talking about this lawsuit right now.
Okay, so the assignment, it didn't have an Exhibit A attached to it. You're saying you just attached what you were given by your client. Is that correct?
No.
All right, so where is the Exhibit A?
I don't know. It could be pages 4 through whatever.
All right, so
I don't know.
5 says the promissory note was subsequently assigned to plaintiff.
Correct.
But there's no detail and there's no reference to the assignments that were attached to the lawsuit. So that's why I'm asking to show a proper assignment. An assignment of Mr. Ward's debt that references the actual debt being attached. It's not there, and you haven't explained the chronology of the assignment, the chain of title. Do you know what a chain of title is?
Yes.
So why did you not break that down as to the chronology of the chain of title in your pleading number 5?
Because these are notice pleadings. We don't attach everything. You attach enough to give the other side an opportunity to know what you're talking about.
Okay.
But no, your complaint's not your be-all, end-all. I know it is
Alright.
for you, but it's not for me.
So the Security Credit Services appears to have created another assignment titled, oh, it's not an assignment, it says Affidavit of Debt and Verified Bill of Particulars. Do you see that?
You're referencing page 20, yes.
Yes, sir. So the undersigned is saying, sworn according to law, that she is familiar with the practices as well as the books and records of plaintiff. Just a side note, this lawsuit was filed on February 3rd, is that correct?
Yes, that's correct. Oh, February 3rd, 2023, correct.
And this affidavit sworn under oath is saying on a month earlier, that Security Credit Services is a plaintiff when there's no lawsuit.
Oh.
They're also referring to Mr. Ward as a defendant when there is no lawsuit. Do you know why they did that?
No.
Did you assist in the creation of this affidavit of debt and the verified bill of particulars?
I did, yes.
Why did you use the word plaintiff in a case where there was no lawsuit?
I don't know, it's just because it was going to be used in the lawsuit when we filed it.
But it's,
And at the time your client would have received same, he would have been a plaintiff?
but it's not true that he was a
Oh.
plaintiff. Is that correct?
No.
All right. When I say he, I mean...
He was never a plaintiff in this lawsuit.
Forgive me. Security Credit Services is not a plaintiff when Security Credit Services swears under oath that they are. Isn't that true?
No.
It isn't true. They were a plaintiff when the December 2022 affidavit was created with your help?
No lawsuit was filed, but we were getting ready to file.
Okay, so we go round and round.
Just
but
like, yeah,
are you
this is
saying
so
that
silly.
plaintiff, they were a plaintiff
It's
a
like-
month before the lawsuit? Yes
It's
or
like
no?
this, Brian. You know when
Just give me a
you...
yes or no, and you can call me anything you want, but I need a yes or a no.
What was the question again?
Was a lawsuit filed at the time, 12/2022, when this affidavit was sworn under oath that
No.
Security Credit Services were a plaintiff? And that's a no.
No, you
Was
got me.
Mr. Ward a defendant in December 2022?
Not in this case, no.
No. And yet you assisted in creating this saying he was a defendant.
Yeah, well, we should settle right now. This is the end of the case.
You don't want to talk settlement on the record. Yes.
Is this your
off the
special
record,
guest?
please.
Yeah, one moment, please. Off the record,
What a joke.
11:51 a.m. We're now on the record, 11:55 a.m. Go ahead, Counsel.
Hi, Mr. Johnson. Again, we took a break. You received the deposition notice in this case from me, correct?
I received multiple deposition notices
And-
from you.
We worked out to this day being when you were available, and you also asked that I put it to 10 a.m. so you could pick up your kid. Is that correct?
No.
All right, go ahead, correct me.
I said on or before 9:30, not 10. And this is the third deposition because you canceled 2 previous ones.
So you received
though-
the latest notice, and you have not officially objected to being here today or the DEP notice. Is that correct?
That's correct.
Okay. So back to the matter at hand. We were looking at the assignment at page 20,
What exhibit?
Exhibit 1.
Okay, thank you.
You just agreed that an affidavit you helped your client sign was signed under oath where you claimed that Security Credit Services is a plaintiff when there was no lawsuit filed, and that Mr. Ward was a defendant when there was no lawsuit filed. Isn't that correct?
That's correct, yeah.
And in this, the affidavit appears to say that the debt was sold to, well, I'm glad that you told me that you were part of this so you can clear something up. You see paragraph 2?
Yes,
Said account was charged off on February 28, 2018 and subsequently sold to Security Credit Services. You're going to know the question I'm asking, but why does it not say who sold it to Security Credit Services?
I don't
And
know.
you wrote it.
I don't know. It's true.
Who sold it? Meaning, to have this be true, you have to have a assignor and assignee.
Yeah.
Who is the assignor in this case for this affidavit to be true?
I don't know if it was the bankruptcy trustee or Realax that did it themselves, but one of those two.
So the answer is I don't know, is what you're saying. You do not know who sold this debt to Security Credit Services.
Correct, I don't know.
Yet
But-
you allowed this to be signed under oath
Because it's true.
because it was assigned, you're saying you just don't know who at the time sold it to that Security Credit Service. Is that correct?
Correct, and it has something to do with the Realax bankruptcy.
All right. Is it your belief that this assignment is proper and by the law or whatever prism you look through, even though it does not say who sold the to Security Credit Services?
No, I would not characterize this as an assignment.
What would you characterize it as?
What it's titled.
Affidavit of debt and a verified bill of particulars.
Bingo.
Okay. Why does it mention that the debt was assigned, but not from whom?
Because it's true.
All right, but if it's not an assignment, why mention that it was assigned? What was the purpose in your placing it, attaching it to the complaint?
Well, usually when consumers receive a lawsuit, they don't know who Security Credit Services is. They have to look at the paperwork and be like, oh, I see this debt, and now I see that Security Credit Services was assigned said debt.
Off the record?
Off the record, 12 p.m. On the record, 12:01 p.m.
At 3, did you write this whole thing, by the way, Mr. Johnson?
It's a template. I didn't write this.
You just said that you contributed to it.
I did, but I don't.
You gave them the template?
It's merged in our system, and we merge it for all these accounts.
Let me ask you this. Did you write the whole thing and just had them sign it?
No. It's merged.
I don't know what that means. Did you write the
It's a
thing
template.
and send it to them to sign?
Yes.
Okay. So this is your work. Okay, so plaintiff, it says, was purchased and was otherwise assigned this charge-off account along with other debts. As a result of the foregoing sale and assignment, the plaintiff succeeded to all right, title, and interest in the charge-off account. It now owns the account. What is an account? Because before it was a promissory note.
This is
What is an account?
account, debt, promissory note.
You're saying they're all the same?
Yes. Dun dun dun.
Is that what you meant when you said account? That it could be the promissory note, or it could be a loan, it could be something?
It's for this affidavit, it would be your client's, Mr. Ward's student loan debt.
All right, but you're not saying that. You're saying it's an account.
I'm
See, in my
saying,
brain, this is how I operate. I apologize.
I know your brain.
Maybe. It goes on to say, in referencing plaintiff, again, even though there's no lawsuit, and its predecessor entered into a contract where the predecessor made representations and warranties that it had clear right, title, and interest in the account, and the account was free and clear of all liens and encumbrances, and it had the power, authority, and full right to sell, convey its interest in the account. Which assignor made their representation and warranties? Number one, they had clear right, title, and interest in the account. Which one?
I don't know.
Well, this was attached to the lawsuit. Why would you not know? And you wrote it.
I don't know. It was either Genesis or Realax or the bankruptcy trustee. Wow. For the record, someone who's not even appeared on this case is handing notes to Mr. Parker.
Oh. So you've said that this is an affidavit under oath that you wrote.
Sure.
I need to know, so that, as you say, you can notify the defendant who the predecessor was that warranted and made representations that had clear right, title, and interest in the account.
I don't know.
Then why would you attach something you don't know is true or false?
My client said it's true. And
You
it is
said-
true. My client was assigned this account.
Okay,
Because your client paid my client $2,500 to settle this debt.
but that doesn't.
Why are we still
mean it
talking
was
about this?
assigned in 2022 or 18. He
Well,
wasn't being sued at that time.
Livonia Properties.
Yes,
Yes.
you're avoiding answering the question.
Because we're talking about a debt that's been settled.
Again, the assignment, you attach to a mediation summary, a counterclaim showing that your client had a perfect chain of title. So it's fair of me to ask, where does it say who sold to Security Credit Services for that chain of title to exist that you have represented to both a state court and federal court as having happened. And my client has no case. So
Correct.
tell me who gave clear right, title, and interest and representations and warranties to that effect to Security Credit Services when you wrote this?
I would have to look at the bill of sale of said Realax, which is not in Exhibit 1.
You've referred to paperwork regarding Realax and a trustee. What do you mean by that?
You did some research, I guess, for your client's case, and you said all that. I didn't know anything about it.
Then who was it you were saying was in
I'm
your
not
page
saying-
20, Exhibit 1, when you represented to your clients, or they represented to you, I don't know, you created this affidavit, you merged it. Who were you saying made representations and warranties? You can't swear under oath to something and not have support of it. Who made those representations?
I don't know. I did not swear to this under oath.
Who did?
Caitlin Cole.
Caitlin?
Lind. C-A-E-T-L-I-N-D.
Okay. And did she ask you any questions about this affidavit prior to signing it?
Not answering attorney-client privilege.
So she was your client at the time?
Yes.
What is her position at Security Credit Services, LLC?
I don't know what her title is currently.
What do you mean currently? What was she before?
I don't know.
Okay.
They're just titles. She works there. She still works there.
So you're saying a document you did not possess, I would find the representations and warranties that you put into an affidavit. Is that correct? You don't have that document. You received it from me. But prior to that, you're saying Realax, you think, or you say you don't know, made representations and warranties. Is that correct?
That's what it says in the affidavit.
And my question, who made those representations, if you know?
It was either Genesis Credit Union, Realax, or the bankruptcy trustee.
And you are saying you did not have to be specific in this affidavit that you had an employee swear to. Is that correct?
I'm saying that everything in this affidavit is true and correct to the best of the signer's knowledge and belief.
Right, you wrote the affidavit. So
Yep.
why can you not tell me, if it's true, where the representations and warranties, who gave them to Security Credit Services?
I don't know. No idea. But they had the debt.
Who's they?
Security Credit Services, LLC.
When did they receive the debt?
I don't know.
You don't know when your client received the debt.
No, I don't.
So you're saying it's not fair of Mr. Ward to say in an affirmative defense or in this federal lawsuit to say you don't know when you got the debt, so you can't hold him accountable. It's okay for you not to know. Is that what you're saying? You don't have
I don't know what you're saying.
You're right. You're absolutely right. Let me rephrase that. What's your duty when you sign a lawsuit?
I have researched the case. It's
Yes.
not fabricated. Damages aren't made up out of whole cloth. The lawsuit was not intended to oppress, harass, annoy the other party, and
All right.
that everything in the lawsuit is true and accurate to the best of my knowledge and belief as an attorney.
Great. So tell me what source you used to the best of your knowledge and belief as an attorney as to which predecessor and interest entered into a contract where it made representations and warranties under your duty as an attorney to research the case before you just put something together, that it had clear right, title, and interest in the account. What'd you use?
I used the documents they gave me, which they I'm assuming they received when they bought the debt.
What document specifically?
Exhibit 1, pages 4 through 19 and then 21.
Let me stop you there. Please tell me where they, I assume you mean Genesis, is representing and warrants that it had clear right, title, and interest.
Genesis? I'm
Yeah,
talking
you're
about Security Credit Services LLC.
No, you're saying
What am I?
you reviewed something
I did.
in creating this affidavit. I'm again asking which predecessor in interest had a contract with your client where they made warranties that it had clear title and interest in the account to give that to your client. Which one?
As I said before,
Okay.
it was either Realax or the bankruptcy trustee. I have no clue.
Why would you say that then if you had no clue?
Because my client had the debt and it was assigned to them,
When?
and nobody else was coming after your client for the
When were
money.
you learning when they were assigned the debt and from whom?
I don't know the who and what. All I know is it landed in my office and we sued on it within the statute of limitations.
Wouldn't you agree that an assignment that is assigning something has to say who the assignor is and the assignee is? Is that correct?
Yes, and what you're referencing on this page 20 is not an assignment or a
But
bill of sale.
Then why would it reference 3 paragraphs worth, and the biggest paragraph is all about the assignment? It is fair game and relevant for me when you, as you quote, have a duty as an attorney to research something before you sign for it,
Right.
has, to quote you again, no clue or no idea where the information came from that you had your client sign under oath. How come you don't have that information?
Again, that's like 6 questions.
All right, you're right again.
Yeah, I am.
Why did you have your client sign something that you don't know is true?
Because they verify that it's true and correct to the best of their knowledge and belief, and they signed same. If it wasn't, they wouldn't have signed it.
All right, so why did you write?
I
Because you don't want to tell me attorney-client privileges.
I don't.
So what is it you received from them when you created this affidavit, again, where somebody made representations and warranties?
It's not in Exhibit 1. You're going to have to find it in the 400 pages of initial disclosures that I sent
Yeah,
you.
but
But there
it's-
is a bill of sale from Realax or the
Is
bankruptcy
that the thing
trustee
that
or
I
whoever.
found? That's the thing that I
No.
found.
It was attached to my, just ask
Attached to
your
your
next
what?
question. Responses to all your stuff.
All right, so why did you not attach that to the complaint that you specifically said on the record?
As I've-
We have to notify the defendant of the case against him. So why is that bill of sale not attached to the complaint?
I don't know.
Well, you said
But
that
it was
you wrote
provided in discovery. Again, we're a notice pleading state. We don't have to provide 50 pages of documents. Number one, the courts hate that when you file stuff with
That's your
hundreds-
reason for doing that? Because the courts hate something?
Well, I want to please the courts. I don't know what you're doing, but yeah, I want to do stuff the right way.
You want to do stuff the right way?
Number two, it costs a lot to mail hundreds of pages to, we're just trying to give
Did you
notice.
just mail me 400 pages?
I did at my own expense.
Okay. So you weren't thinking about my feelings of receiving all that information?
There wasn't a pleading. It wasn't filed with the
It was
court.
called an initial disclosure. It's exactly a plea.
Did I file it with
You're
the court?
required. I don't know. You're not supposed to.
I didn't. It's a discovery document.
What do feelings have to do with why you file something? What do feelings have to do with that? It's the rules.
Oh, the rules.
So when you create an affidavit that you're having your client sign, are there rules to follow?
That what they're signing is true to the best of their knowledge and belief.
So it doesn't matter if you know it isn't?
That's funny coming from you. They signed it. It's true.
So in a
And
sense,
if not, they committed perjury, right?
I don't know. It's your belief.
And it was good enough for your client to settle this debt for $2,500, even though allegedly you had an affirmative defense that could have wiped this out. You ever talk to your client about that?
So go to 6.
All right, 6.
The internal account summary of plaintiff is attached here to Exhibit A. There's nothing attached to Exhibit A in your complaint.
Sure, there's only, pages 4 through 19.
So that was attached to the affidavit of debt and verification of bill of particulars? Are you saying is that
I don't
because it's
know.
your lawsuit?
Right, it is my lawsuit.
So are you saying that was attached? You attached
I
it?
attached the loan application, pages 4 through 5.
Let me stop you there. Was that what she was referring to when she signed this?
I don't know.
Did you want her to believe that Exhibit A is attached to the affidavit?
I don't know.
Then why did you say it as the person that wrote this affidavit?
I didn't testify to this. This was my client.
Yeah, okay, fair enough.
So
wrote
enough of this.
Yes?
And you can't put them in this lawsuit because you already counterclaimed them.
Anyway, you wrote this.
I drafted it, yes. And then my
Okay.
client testified that it's true, and I believe that everything, if it wasn't true, she wouldn't have signed it.
Right. So what did you give her to show what you believe to be true?
That's attorney-client. I'm not getting into that. Just stop.
Well, it is an attorney-client because you're literally saying this is what happened. So I would like to know, where's the contract that says a predecessor made representations and warranties that you refer to in creating this?
I don't know. It's probably in the 400 pages of documents I gave you. I don't know.
Is that your testimony? It is there?
It should be. And again,
So Exhibit A is attached, that wasn't attached to the affidavit, will be found in the 400 pages.
I don't know.
And why wasn't it attached to the lawsuit?
Because we're a notice pleading state.
Okay,
And
but you just told me what a pleading is versus a non-pleading, and this isn't a pleading.
it's attached
So
to a
you don't
pleading.
have loosey-goosey violations of the law when you create an affidavit. Where is Exhibit A?
I don't know.
But you wrote Exhibit A for your client to sign off on.
I guess, yeah.
So what was the Exhibit A you were looking at when you gave this to her?
I don't know.
Then why did you include it?
I don't know.
You don't know why you did something or didn't do something?
No, I really don't. But I did attach documents showing your client that this is relating to the student loan he took out.
Okay, but what about the document we're talking about? Page 20.
Yeah?
Did you provide them with Exhibit A?
No.
Then how are they supposed to know what Exhibit A is? How is my client supposed to know what Exhibit A is?
I don't know.
Okay.
I'm not your client.
So this complaint you tried to serve personally, is that correct?
Correctamundo.
Is that a yes or a no?
Yes.
Yes, okay, thank you. And you were unsuccessful, and you asked the court to allow you to, you made a motion for verification for alternate service, is that correct?
Correct.
And let's make this Exhibit 6, please. Thank you very much. I'm handing you, let me do this for you.
Yeah.
Oh, I already did it. I'm awesome. So this is already, there's numbers of not pages, 9 pages there.
Ooh,
Oh, I
thank
think
you.
that's, did I already give him this?
I am.
See if you are, do you have number 6?
I don't know. You're passing papers all over. Oh, that's a good one.
Is, back to Exhibit 1, page 20.
Yeah, where is it?
Back
Thank
to Exhibit
you.
1, page 20.
Okay.
The merge that you were talking about.
Oh, yeah.
Did Exhibit A, was that part of the merge, meaning it was already in the document?
No.
So you put Exhibit A in there?
Sure.
Yes?
Sure.
Yes?
Oh, God, yes.
Okay. So what was the Exhibit A that you put in there?
I don't know. I'm assuming it was all these other documents I attached to the lawsuit.
Okay. You wanted your client to sign off on that.
Yeah.
Did you give her Exhibit A?
I don't remember, and that's attorney-client privilege, and I'm not getting into that.
Well, if I can't talk to her, which I can.
Yeah, you
whether
can.
You're thinking she's going to be able to tell me what the Exhibit A she looked at.
I don't know.
And she'll be able to tell me whether you gave it to her.
I don't know, but you've already sued them
All right.
in a counterclaim.
Okay.
So they're
get to that.
done.
We'll get to that.
Okay, let's
Okay.
go.
All right. But let's stick to what we're talking about.
Yeah, sure.
Okay. So the merge that you talk about, I think what you're trying to say is that the affidavit was a template.
Yes.
And you just put information that you had at hand into the affidavit, correct?
Bingo.
What was that information you had at hand?
The account number, your client's name,
Exhibit A, which you don't have?
Exhibit A, yeah. Ooh,
All right.
That's a bad one.
So, let's look at Exhibit 6. I'll hand that back to you. Oh, my trusty.
Oh, boy.
Eh.
Joke.
Oh. Forgive me. Going back to Exhibit 1,
Exhibit 1.
that is page 19, page 20,
Yep, the infamous page 20. Yes.
infamous. Where does it say, and you created this,
Uh-huh.
that she's signing under penalty of perjury?
I don't know. Before
You wrote it, so you tell me. I mean, assuming you know how to write an affidavit.
the undersigned being first duly sworn according to law, Deposition says. Yeah, it doesn't say the word perjury, but
And you, an attorney, wrote that.
you got
you
me.
understand-
You got me again.
Well, I'm not trying to get you in any way, shape, or form.
No, it's not what
But
you said earlier.
Do you understand that an affidavit is not an affidavit unless it's signed under penalty of perjury according to the Sixth Circuit's?
No.
You don't understand that? Should you
It's
know
just
something
an
like that?
affidavit. I don't know.
So you don't think it's important? An affidavit's that important?
Not really, but it's there. You could have filed without it.
So there is no perjury statement being made in this affidavit.
I guess not.
Not saying that she fears being subject to perjury if she doesn't say the truth.
I don't know.
And you, as her client, as her attorney, wrote this for her.
Right?
Did you purposely leave out the part of, let me finish. Did you purposely leave out the part about being signed under perjury? Yes or no?
No.
Why did you not include it in the affidavit?
I don't know.
Again, you don't know.
That's right.
And is that the basis of most of your work that you do, or just this case? Because that's all you've said about why you do what you refer to. So in every case that you act as a debt collector, is it based upon I don't know, like here? Yes or no?
No.
No. So usually you do know? But in this
Usually.
case, you don't know.
I know, but we're talking about stuff that's pretty old. I don't recall every
This was
detail
literally
about
a
this
year ago.
case.
It was literally a year ago.
We're coming up on 2 years, but
All right.
go ahead.
You said there's nothing wrong with your memory today. Is that correct?
No.
You're on no medication that impacts your memory, correct?
No.
All right, and you literally had this case in your office where you sent me 400 pages after reviewing it. Is that correct?
Literally, yes.
Okay, so, and now you say you don't know most of the time when you file your own documentation and sign that it is true. Is that correct?
I think everything that I signed is correct. Tell me where
When?
it's not.
When? You want me to tell you when it's not correct?
Yeah.
We'll get to that.
Okay. Because I'm really interested, because your client paid $2,500 to my client.
Do you still continue to do this?
I don't even know what you're saying.
Do you create this merged affidavit without the words under penalty of perjury with all your clients?
I don't know. I don't know what the velocity affidavit says. I'm sure you do, because you've seen enough of them.
All right, so you're saying you write the velocity affidavit too?
Wow, what's your memory like? That's already been sworn under oath in a prior dep, which you've done videos on.
Well, okay, so what's the answer?
Yes.
You write the velocity affidavit, and it doesn't say sworn under penalty of perjury.
I don't know what it says. You've seen enough of them.
Well,
why are we
if I-
talking about velocity in this
How many
case?
velocity cases do you do a year?
A lot. They're
And
like our
you-
biggest client.
I don't know why you're looking at me like I should know that.
Because you're on every velocity case and you come
I
in.
am not.
There was a Century Law Firm case where you swiped the case from another attorney, probably because I was on
Okay,
it.
how is that answering my question?
Because
Are
it
you
shows
saying
that
you
this.
have many velocity cases where you create the affidavit, but you don't know whether you, after hundreds of writing of these affidavits,
Yeah.
using a merged form, you have no idea if it says under penalty of perjury.
No clue.
Will you be changing that today?
No.
So you're going to continue to give your clients affidavits that say under penalty of perjury. You're going to continue to do that for your clients. Are your clients aware that you're literally creating an affidavit that is against the law?
Gosh.
Because you keep referring to how your client signed under penalty, under oath, but she didn't.
Okay.
Why are you saying that? Again, you're saying things that aren't true.
No, you got me
are you
again.
saying- whether I got you or not, I'm here to find information. So why
About
are
a
you
settled
having
case?
Sorry?
The case is settled. Why are we still talking about this?
Because to use your words, the lawsuit I'm suing you is based upon this, to use your words.
Ooh.
So, why, I think, and I don't know, you have many opinions about how bad a job I do, but I think it's malpractice, don't you agree? Yeah, you're a former debt collector. When you give your client something to sign as an affidavit, and it doesn't have under penalty of perjury, specifically, Sean Cox in the Eastern District of Michigan has written specifically that the affidavit is not an affidavit without under penalty of perjury. You're a member of the federal bar, sir?
Yes, sir.
And you aren't aware that you have to put that in? Oh, retract that question. Are you aware that an affidavit requires under penalty of perjury? Yes, sir. Are you aware of that? Yes or no?
No. I don't know. You filed that lawsuit with Judge Cox and he dismissed it.
That's not the one I'm referring to.
Because you had to get some affidavit because you didn't have them notarized.
I am glad that you just made this relevant.
Oh my God. Yeah, when did your client sign his affidavit? Still don't have that date.
Off the record for a minute, please. Anybody wants to smoke them or?
Off the record, 12:30 p.m.